You don't get to go in and deliberate. I'm going to send these guys in to do it without you. It'll probably take twice as long without a woman in the room. I'm just probably, that's probably true. But what I'm going to do is I'm going to encourage you to stick around. You're ready, Mr. Leckie.
Yeah. This is one sent to the members. There was a domestic relationship. Your testimony from Ms. Marquita Thompson was a domestic relationship with David 6 months. And I had to prove that there was some phone call. And then that violence happened on February 25th. 2024 at the Wayne County Airport, or I'm sorry, yes, at the Wayne County Airport in Wayne County, and that it happened on or around. Now, you heard from Ms. Marquita. You heard how she came out from me. We saw a video where it shows her walking through the park. Then we heard how she saw the defendant's car parked by. We saw a picture of the defendant driving around, and we saw Marquita walk. Fortunately, there's no video happening actual. So we had the moments before, and we had the moments after. So we heard Marquita testify and grabbed her right collar. But we do have pictures. We do have pictures of what the result right now. This was 30 minutes after when she got the point of her cover. Now, we heard that after this happened, she got to her car. We saw in the video lights turned on. Then for a moment, we saw the lights here. We saw both cars move both up the aisle. And we heard testimony from the detective or superintendent that one vehicle stopped, the other vehicle stopped. And then we see Marquita Chevrolet wiggle past the defendant, in which we heard that both of these vehicles then exited one way. Now we heard from Ms. Marquita Thompson that she was driving down for a speed to get pulled over to get help. She didn't call the cops. She didn't call until that night when she got home. Now, we saw that they had robbed. She goes to the police station the next day, telling after officers in Dearborn told her, hey, it's not here, happened on airport property, go there. She goes there. Now, I know some questions about where these because now, as the judge instructed these pictures on, and the look for us, and the officer looked on, captured this one, and saw her face when she came in, and she still had that. Now, ladies and gentlemen, people assert that we've never beyond reasonable doubt. And now he asks you to use your reason. As Judge Oakley instructed me in a minute, that at the end of this, thank you all.
Mr. Starr.
Well, when I was in law school, procedure from a law professor said, you have the concept of reasonable doubt. Look at things different. If I were to have reasonable doubt, that's saying if I had that concept down way back in the 90s, I would have told my friend Des, hey, play the next song. He wouldn't have been able. I think there's things here where we can say, hey, play the next song. You're not able. For example, the victim testified that she was parked front of the defendant's car behind him. She's in front, he's behind. But yet when we see the video, we see lights come on. We see the car move forward. Whose car was it? You saw her car, but the other way around. And that the old Malibu pulled up in front. How was that possible? Can't back up. It's a car back. Doesn't make sense. But then also, too, we have some alleged evidence that's either missing or not here. The security video. They said there was more security video, but I don't know, timestamp. So I don't know. Those have to show, okay, this photo was taken this date. Don't have that. Pictures of her face when she made the police report. That's easily shown. Don't have it. What about this? What about proof that my client is calling her teams that she then blocked the number, and then that my client supposedly called from other numbers? We have proof of that as well. That's not it. Now, going back to the point about Einstein and David Barlow, as we see with this one, she's wearing a tank top. This one she's not wearing. Which one was first? Which one was taken first? All right? These are her photos from her phone. It's not from the tank top. It's like a collar shirt. So let me ask you this question. Is that she was grabbed and punched in the face? Not sure what was in. Is this a bruise or a bump? Is it a bruise or a bump? A bruise? Yeah, you possibly could infer it. Someone possibly did do that. Could have failed as well as other scenarios there, but a bump. See them? So there's reaction. No, it's a bump. It's not a bruise. I would suspect if someone punches you in the face, you're going to have a bruise, not a bump on the lip. That's why I asked the question. Any other swelling? Instead, we just have this bump right here. You're going to be able to watch the video in the future. You guys are going to go back there. You guys are going to break off about the stage together. I want you to think about this question instead. Right? You think about it, you can play the next song. You can't play the next song, you gotta come back like this.
Mr. Leckie.
So we did your testimony about my two. Now, this one collared shirt. That same collared shirt she's wearing. So when she got home, she took this picture. She said 30 minutes. Now this one said about an hour. She changed her channels. Took pictures from different sides of the swelling. Now, We didn't hear testimony. We didn't hear testimony about where she, but we heard testimony about how this defendant came to her place of work. Because couldn't get a hold of her any other way, trying to get in touch. Just trying to get, and when she wouldn't comply, when she told him she's not his anymore, he punched her. Now, I'm going to ask you again, that based on that you find this defendant guilty.
Thank you, gentlemen. All right, folks, time for more criminal jury instructions. These are your final instructions. The evidence and arguments in this case are finished. I will now instruct you on the law. That is, I will explain the law that applies to this case. These are under final instructions if you want to follow along. I'll give you a chance to get there. Ms. Vanderfleck, you having trouble? Okay, all right.
That the law says the elements of the crimes.
Not yet. Starting with final instructions, bold print at the top, and right under that page 1, duties of judge and jury. We're good? All right. Paragraph 2. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way, to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that. A doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witness's answer. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I may have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witness you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have, and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was there anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but said the truth about others, you may simply accept the part that you think is true and ignore the rest. The defendant is charged with domestic assault. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant battered Marquita Thompson. A battery is a forceful, violent, or offensive touching of a person or something closely connected with him or her. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Marquita Thompson's will. Second, that at the time, Marquita Thompson was a person with whom the defendant had or previously had a dating relationship. A dating relationship means frequent, intimate association primarily characterized by the expectation of affectional involvement. It does not include a casual relationship or an ordinary fraternization between two individuals in a business or social context. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about February 25, 2024, within the Wayne County Airport. When you go to the jury room, you will be provided with a written copy, your tablet, of the final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a business-like way and that everyone has a fair chance to be heard. During your deliberation, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on the verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual, considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. Possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the court officer. It is not proper for you to talk directly with the judge, lawyers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any or all of the reference documents or exhibits that have been omitted, ask for them. When you go to the jury room, you will be given an electronic copy of the instructions you've just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. The attorneys and I have all approved a jury verdict form. That will go in with you to the jury room as well. Now, if you flip back to the little blue index, I'm going to evidence instructions. Page 1, circumstantial evidence. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. If you believe that a witness previously made a statement inconsistent with their testimony at this trial, the only purpose for which that earlier statement can be considered by you is in deciding whether the witness testified truthfully in court. The earlier statement is not evidence that what the witness said earlier is true. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you are not required to do so. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that he meant to do so. Back to the index page, folks, for witness instructions. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proved beyond a reasonable doubt that the defendant is guilty. You have heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witnesses. Gentlemen, are you satisfied with the instructions as given? Thank you, gentlemen. All right, folks, this is my least favorite part of a jury. If you can count, you see there's 7 of you. And I've said a couple times it's 6, 6, 6, 6. So that means one of you get kicked off. And the reason I hate that so much is I've been watching. You guys have all been engaged. I mean, I didn't, Mr. Sharp wasn't sleeping, so I want to kick him off. Everybody was listening and engaged. And I mean, you asked great questions. So I've got 7 little beads in this little box, and they've each got a number on it. One of them is going to be yours. Juror number 6, Ms. Vanderklee. So here's what I'm going to do. You don't get to go in and deliberate. I'm going to send these guys in to do it without you. It'll probably take twice as long without a woman in the room. That's probably true. But what I'm going to do is I'm going to encourage you to stick around. You don't have to. I'll release you officially right now. But I'm going to encourage you to stick around because when we're done, when they've given their verdict, when I've shared that with the courtroom, I'm going to go back in there and I do what I call my debrief. You're invited back for that. And I'm also going to ask each of you if you'd be willing to stick around and give some feedback to the attorneys if they want. Because I've done this with every one of my jury trials since I got on the bench in 1999, and I can't tell you how many times I wish I would have had the chance to do this with my jury trials that I did as an attorney and get some actual feedback. I think it can be very, very effective feedback for a trial attorney to listen to what you folks are thinking after you watch him in action. All right? So with that lecture, you can leave. The rest of you might as well all get up because now Joe's going to take you back in and make you work. This is the time to take your notepads, your tablets. Yeah, questions?
Yeah. What are the charges again? Is it just one?
Just one charge. The charge of domestic violence. Yep. So take your tablets if you want them. Take your notepads if you want them. Your waters, whatever you want to take back there with you. If you forgot something, we can get it later.
You allowed to have the photos?
Yeah, you can take those back right now. Mr. Leckie, you got them? If you want to see the video again, we'll bring it back out here and play it out here on the big screen and the little ones in front of it. Right. You can just have a seat. Yeah.
Are you breaking from lunch?
I don't think you're breaking for lunch.